Today, we're going to be jumping into another argument that James Owens made on behalf of Sarah Boone seeking a new trial. So we already spoke about the first argument. We went through the case law on that. We spoke about the second argument in our last video. And today we're going to be concentrating on the third argument that James Owens makes on behalf of Sarah Boone, why she deserves a new trial. So before we jump into that, I just have two quick announcements. Number one, I do want to give out a shout out to the sponsor of this video, the Suit Depot. It's a store that sells high quality suits for a very reasonable price, as well as other apparel, by the way. And it's a very reasonable price. And on top of that, you get 10% off by being a listener and follower of Brother Counsel. So when you are checking out of the store, the link is in the description. There's a coupon box where you can put a coupon code. You just type in Brother Counsel, all lowercase, no spaces, and you will get 10% off. You already discounted and very reasonable pricing of the Suit Depot. Number two, we are going to be going into cases today like we always do on this channel, but these cases today are somewhat triggering. They're hard to read. The facts are, some of them could be a little bit gruesome, and it can elicit some emotional responses from you if you're watching this video. So I just want to warn you that if you continue to watch, you are going to be hearing about some of the facts of these cases, which are very difficult to hear about. So if this is going to affect you and you're not going to be able to really, you don't do well in these circumstances, well, then maybe you should just turn this off and come back for my next video. But the cases that we're just going to be getting into today are just, some of them are very, very gruesome. So you are forewarned. And with that warning, let's go on to the motion. So James Owens filed a motion. This is the third argument that he's making why Sarah Boone deserves a new trial. So here we go. Let's pull it up. Argument 3. The court erred when it denied a motion for a new trial due to an emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. And for this conclusion, James Owens cites these cases: Nebergall versus State, Smith versus State, and Cullen versus State. So obviously we're going to have to go and look up these cases and see whether these cases actually stand for this proposition or not, and whether they are similar in their facts to what happened here. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. And that's it. That's the entire third argument. Argument 3, very short, but they do cite some of these cases. So we have to see whether these cases actually stand for that proposition. But first, let's see what that outburst looked like. If you watch the trial, then you know what it looked like. But in case you didn't, let me show you what that outburst actually looked like. So it was during the prosecutor's closing arguments, and they were showing a video of the suitcase when George was still alive, and he was begging Sarah to let him out, that he couldn't breathe. And it was during that clip of the video where there was this emotional outburst, as James Owens calls it. So here we go. I'll play it for you, and you'll be able to see for yourself. And again, the volume is cranked up as much as I can, so we are left with whatever audio was available in the courtroom that day. So here we go.
Yeah, that's when you do me, shake me.
Now, you may have just heard James Owens. James Owens just said right now, I'm asking you to leave the room. So something happened right then. I don't think we could hear it. I didn't hear anything, but something happened where James Owens, we can just hear slightly, said, I'm going to ask you to leave the room. So let's see what happens. So there you have it. And then the closing argument continues. So that was the emotional outburst that James Owens is referring to. Now, definitely there was an outburst. There was something happened over there, and they left the courtroom. So there is some sort of distraction to the jury. The question is whether that outburst is going to be enough to be considered that the jury is so prejudiced that it's not fair, and therefore a mistrial should be declared. So that was the outburst. Let's see what the case law has to say about this. So let's pull up the cases. The first case that they cited was Nebergall versus State. Let's see what happened in Nebergall versus State. Here we go. The defendant primarily argues that the trial court erred in denying his motion for mistrial after the alleged victim intentionally violated the trial court's clarified order on a motion in limine. So what happened here is actually there was a conviction. The trial was about an attempted sexual battery on a victim who's 18 years of age or older, while in the possession of a weapon, and one count of simple battery. So that was what he was charged with, and he was found guilty. So the defendant primarily argues that the trial court erred in denying his motion for mistrial after the alleged victim intentionally violated the trial court's clarified order on a motion in limine. So what happened here is that the trial court had an order, and in this order, it was very specific what the victim is allowed to testify to and what the victim is not allowed to testify to, or any witness for that matter. And here you have the victim intentionally violating the trial court's order. That's what happened. What did the order provide? Well, the order provided, in pertinent part, that any testimony regarding law enforcement's efforts to identify the DNA found on the alleged victim's buttocks could only indicate that such efforts were inconclusive. So the only testimony that they're allowed to say is that the DNA on the alleged victim's buttocks were inconclusive, and you can't connect it to the defendant. However, during the alleged victim's cross-examination, in response to one of defense counsel's questions not related to DNA, the alleged victim ended her answer by exclaiming, "You see the DNA results on me, and now you guys say the DNA is not on my butt, but it was on my butt. It was enough." So very clearly, she violated the victim violated the trial court's order, saying you can't say that. And therefore, the defendant moved for a mistrial. The trial court denied the request for a mistrial, and therefore it got sent up on appeal. And now they're asking the appellate court what to do about this. Well, this is what the appellate court held. We agree with the defendant that the trial court erred in denying his motion for mistrial. The alleged victim's comment deprived the defendant of a fair trial, reasonably may have materially contributed to his conviction, and was so harmful or fundamentally tainted as to require a new trial. We also conclude that a curative instruction would not have remedied this violation. We are compelled to reverse and remand for a new trial. So this is what the court held. The court held, look, there was an order. Very clearly, there was an order by the court. The court understood what the danger and the damage could be by saying this testimony, which is not really true, or the extent that they could say is that it's non-conclusive or inconclusive. So the judge understood that, and that's why the judge made that order. That's why the judge entered that order. And here you have somebody intentionally violating the order. Now, does this have anything to do with an outburst? No. This case has really very, very little to do. In fact, nothing to do with an outburst. Now, the trial court, the opinion goes on for a long time, breaking it down into 5 different parts. But really, if you look at the facts, this has nothing really to do with an outburst. This just has to do with violating the court's order, and when you're saying something to the jury, which is very prejudicial. So, yes, I guess you can try to say, well, you see, in this case, you have somebody saying something which is prejudicial to the jury, and therefore, also in this case, when there's an outburst that could also be prejudicial to the jury, so therefore that should also be considered too prejudicial and require a mistrial. But the obvious distinction is that in Nebergall, you see very clearly the judge understood the danger. The judge specifically entered an order saying you cannot do this, and then the victim goes and intentionally violates his order. So then obviously there's much more of a reason to grant the mistrial in this case. So Nebergall is not the greatest case that would help Sarah Boone if you're trying to talk about an outburst. If you're trying to talk about an outburst, then what you should do is find cases that have to do with outbursts. That's really what you should be doing. So not the greatest case. Still, I guess I can see how it's somewhat relevant, but not the greatest case to cite and very easily distinguishable. So the other cases actually are a little bit more on point, and we'll go to those cases next. The next case, and they're going to be getting worse and worse in the facts as we go on. So just as a warning, we may be hearing about some very heart-wrenching facts soon. So the next case they cite is Smith versus State. So this is what happened in Smith versus State. A little bit worse than, more factual than the last case. On June 21st, 2013, Smith met 8-year-old Cherish Periwinkle. So this girl is an 8-year-old. Her sisters and her mother, okay, so Smith, this guy Smith, who's the defendant in this case, he met this 8-year-old, her sisters, and her mother, Rain, at a Dollar General in Jacksonville. Smith overheard Rain explain to an employee that she could not afford to purchase a dress for Cherish. So Rain, the mother of Cherish, wanted to purchase this dress for her 8-year-old daughter, and she couldn't afford to purchase it. She didn't have a lot of money. So Smith offered to drive the Periwinkles to Walmart and buy clothes for the family. So seems like a good Samaritan. He's overhearing a conversation. He says, look, I have some money. I'm happy to help you guys out. I see you need the help. And that's how it seemed. So what happened? Smith explained to Rain that his wife had a gift card and would meet the group there. At Walmart, they shopped together for hours. It got late and the Periwinkles had not eaten. So Smith said he would buy them all cheeseburgers at a McDonald's inside the store. Wow, this guy sounds like he's just so nice. He's buying them food. He's buying them clothing. Instead, at 10:44 p.m., he vanished with Cherish. So Smith all of a sudden vanishes with this 8-year-old girl, Cherish Periwinkle. Surveillance cameras caught Smith leading her to his van, as well as the two of them driving away. Cherish was not seen alive again. The next morning, with the help of witnesses reporting the location of Smith's van, police located Cherish's body in a creek behind a church under a pile of debris. Cherish had been brutally raped, then strangled to death. An officer identified Smith, who was soaking wet, behind the wheel of the same van that had left Walmart. It contained the things Rain had bought at Dollar General. Smith was arrested and charged with kidnapping, sexual battery of a person under 12, and first-degree murder. Okay, so this was a very publicized case, and let's go on to see what actually happened with this specific situation. So you had here, later in the proceedings, the state called Dr. Rao to testify to the extent of Cherish's injuries. Dr. Rao explained that she had testified in hundreds of cases as an expert witness, providing her opinion on various potential causes of death. Dr. Rao had performed Cherish's autopsy and had been present at the creek when her body was recovered. As Dr. Rao testified, the state introduced 26 pictures of Cherish's autopsy into evidence. Dr. Rao described injuries on Cherish's scalp, chest, legs, arm, neck, chin, lip, nose, eyes, genitals, and throat. When the prosecutor asked Dr. Rao about Cherish's throat, Dr. Rao stammered slightly, and the following exchange occurred. From the prosecutor, I'm going to show you 2 more photographs of the dissection taken of Cherish Periwinkle's throat. Will you first tell the jury what you saw when you dissected her throat? Dr. Rao, yes. So what we do is, and then there's a break. I'm sorry, I just need a break. Have about 5 minutes. The court, you want a 5-minute break? I think we'll all take a break for 10 minutes. Thank you. So that's what happened. That's essentially what happened. The judge dismissed the jury, and the defense counsel moved for a mistrial. The defendants moved for mistrial, arguing that Dr. Rowe's response was so prejudicial that it cannot be cured by any jury instruction. The court denied the motion. Okay, so then the case continues. Now, on appeal, they raise a whole bunch of different issues, but the issue that we need to look at is the abuse of discretion for the motion for mistrial, which is B. So let's take a look at B. B. Next, Smith argues that the trial court erred in denying his motion for mistrial on account of the interruption of Dr. Rao's testimony. While testifying to the injuries that Cherish sustained, Dr. Rowe paused, took a breath, and asked to take a break. The trial court promptly recessed. Smith contends that this pause was tantamount to a breakdown and asserted the only way to cure the disruption was to declare a mistrial. We disagree. So this is a situation where this is not a disruption which warrants a mistrial. And then they say, and this is important just to know, that we review the denial of a motion for mistrial for abuse of discretion. We spoke about abuse of discretion. Abuse of discretion is the highest. It's very, very difficult to overcome that. Nevertheless, we do find it, but it's a very high burden. So it's abuse of discretion. And a mistrial is appropriate only where the error is so prejudicial as to vitiate the entire trial. A very high standard. When reviewing a motion for a mistrial dealing with emotional outbursts from witnesses, appellate courts should defer to trial judges' judgments and rulings when they cannot glean from the record how intense a witness's outburst was. So here again, we saw this video talking about our case, Sarah Boone. We didn't really hear anything, so we don't know what exactly happened in that courtroom. But the judge who was there, so the appellate courts are going to defer very often to the trial judge's judgments and rulings when they cannot see from the record itself how intense that outburst was. The fact that Dr. Rowe took a break during her testimony did not affect the fairness of Smith's trial. The jury saw no outburst of emotion. From its vantage point, which was closer to Dr. Rowe's reaction than ours, the trial court determined that a recess was appropriate and a mistrial was not. We cannot say this was an abuse of discretion. This case is not like the one cited by Smith, where a witness's outburst injected into the proceedings a concern for the emotional distress of another sufficient to distract the jury from its work as finder of fact. Okay, Cullen versus State, which we are going to get to next. Here, Dr. Rowe paused, caught her breath, asked for a break. She did not state why she was requesting a break, and when testimony resumed, Dr. Rowe spoke clearly and did not appear to the jury to be in any emotional distress. Smith objects that the trial court should have given a curative instruction after Dr. Rowe asked to pause. The response to a witness outburst is also better left to the discretion of trial judges, who are in the best position to assess the intensity of the outburst and its potential effect on jurors. So there was this case of Talley versus State, where the defendant suggested in the case to adopt a new standard, which would require trial courts to poll the jury anytime that there's an outburst during trial proceedings. And the court said, no, we don't always have to ask the jury, oh, how did that affect you right now? Are you completely prejudiced now? You don't have to do that. That's what Talley versus State said. That's the 2019 case. So here, again, we cannot say the trial court abused its discretion in declining to give such an instruction. So in this case, this is where Dr. Rowe had to take a break, had to take a breather, and that was it. So that wasn't such a crazy amount of an outburst, which would require a new trial. So does this specifically help Sarah Boone's case? Well, not necessarily, because it just says that in this case, actually, the mistrial was appropriate. So this Smith versus State case doesn't either directly help Sarah Boone. Now, it does talk about the idea of an emotional outburst. It does say that there are times where an emotional outburst could be considered a reason for a mistrial. But in this specific situation with Dr. Rowe, where they just took a breath and a little bit of a break, that wasn't considered too much of an emotional outburst. So if you'd ask, from what we've seen, I showed you that outburst. From what we've seen, it didn't seem to be so drastic. So let's move on to the next case, Cullen versus State. And that's the final case where they cite, which they're arguing should really help them in their motion. And this case is really very difficult to read. So again, you're forewarned before we get into this case. This is Cullen versus State. All right. Cullen was charged with the sexual battery of a 4-year-old girl after she reported an injury to her mother and identified Cullen as the man who touched her. The state presented no DNA evidence implicating Cullen. Its case relied primarily on the victim's identification and the opinions of the examining physicians who observed her injuries. At trial, the state called the mother to testify as to the victim's hearsay statements pursuant to Section 90.803 to 23 Florida Statutes 2012. The record reflects, and the parties agree, that the mother was visibly upset and that she cried throughout her testimony. When the state sought to introduce a close-up photograph of the victim's vaginal injuries during the mother's testimony, defense counsel objected. Okay, so they're about to show the mother of this 4-year-old girl who is right now the victim, is being the victim of this defendant, Cullen, for this sexual battery. And they're going to be showing the mother pictures of her vaginal injuries. You can imagine what type of emotional outburst this could prompt. So the defense understood this. So the defense, and again, the mother was visibly upset throughout her entire testimony, and she was crying throughout the testimony. But now that they're about to show her these close-up pictures, the defense says, you know what, he objected, and they went to the bench. At the bench conference, on the objection, the defense stipulated to the photo's admissibility. So the defense said, I understand that this photo can come in. I understand it's evidence of the battery. Okay, it can come in, but objected to admitting it through the mother because the photo had previously elicited an emotional outburst from her at a pretrial hearing. The defense expressed concern that showing the photograph to the mother at trial would evoke a similar emotional outburst that would prejudice Colin before the jury, and argued that it would be less prejudicial to introduce the photographs during the testimony of the examining physician who took them. So he's saying, the defense attorney is saying, look, it's okay that the pictures come in. I just don't think it should come in through the mother, who's going to completely lose herself on the stand now. Let it come through the examining physician. The examining physician who sees these pictures will say, yeah, this is what it looked like. So why don't you do it that way? Although the trial court noted that the victim's mother had been crying throughout most of her testimony and was pretty upset as it is, as you can imagine, the court overruled the defense's objection. So the court said, nope, if the state wants to present the photographs through the mother, then that is what's going to happen. Well, here we go. The state then presented the photographs to the victim's mother and asked her to identify what was depicted therein. She replied, "It is my daughter's vagina." While the state was publishing the photograph to the jury, the victim's mother stated twice that she needed to throw up and then vomited into a trash can, which was provided by a prescient bailiff. The record reflects that this occurred in front of the jury box and within clear view of the jury. The defense moved for a mistrial. After a brief bench conference, the court announced a recess, and the mother was escorted to the restroom. Although the trial court agreed with the defense and expressed its doubts that there was a curative instruction that could adequately address this incident, it ultimately denied the defense's motion for mistrial. This was error. Okay, so this is where in Colin versus State, the Court of Appeals is holding that this was too much error. Okay, to ask a mother to talk about these pictures of her daughter who's 4 years old, who was the victim of a sexual battery, and she's already, as you can imagine, talking about it, and now you're going to show her actual pictures, and then what happens? She twice needs to throw up and vomit into a trash can. Well, this was error, and that's what this case found. Now here we go. Again, they say, we have found no case that involved a particular emotional outburst at issue in the present case. And the cases cited by the state are factually distinguishable from the present case. Okay, so again, they say that this was too much. This was just too much. Throwing up twice, that's just too much. So here you have a case, again, where there is an emotional outburst, and that outburst was deemed to be too prejudicial on the jury, and therefore a mistrial should have been declared. So the question is that similar to the outburst that happened here? There you had, first of all, a witness who was on the stand right in front of the jury, looking at pictures of her daughter's private areas, she was her 4-year-old daughter, and she threw up twice in front of the jury, then had to take a break, and was already hysterical on the stand. So is that the same of what happened here when you have some of George's family who we didn't hear any major outbursts? It could be that they were tearing up or crying or, making some slight noises. If it would have been a loud noise, I think we would have heard it. Definitely didn't throw up, and they weren't on the stand. They were in the gallery. So is this a case that's really going to help Sarah Boone or not? And the answer is, again, most likely not. So that's, again, these are the 3 cases that they cite to show that an emotional outburst in court like this, you're required to grant a mistrial. And although they are right that there are occasions where an emotional outburst could so prejudice the jury that it's not fair anymore and a mistrial should be declared, well, was what we saw such an incredible emotional outburst that it would affect the jury's deliberations. And again, this is an abuse of discretion standard, which means that they take the judge's word much more, especially when it has to do with what type of outburst it was. So when the judge denies this motion, most likely when he's talking about this argument, he'll probably say, nobody heard the outburst. It was a very small whimper or something. And then they simply left the courtroom quietly. It's not like they were screaming as they were leaving. It's not like they turned to the jury and said anything while they were leaving. They simply just left the courtroom, and then everything continued. So again, these 3 cases that James Owen cites, the first one really has very little to do with this. The next 2 do have to do with the idea of an emotional outburst. The second one is more damaging to James Owens because there even though the person had to take a break and they were on the stand in that case. And it's most likely because they were getting emotional about what they're looking at. They both do not, and that doctor in that case, it was not considered enough to declare a mistrial. So it wasn't abuse of discretion then. And the only case was the third case where there was considered an abuse of discretion and a mistrial order. But that case was obviously extremely, extremely distinguishable from what happened in Sarah Boone's case, right? So we don't have to go through all those details again. So this is taking you through the third argument of James Owens in the Sarah Boone's motion for a new trial, which again, we're not finding too much merit in each of these arguments. So again, although there is a concept of an emotional outburst being a problem, but the emotional outburst that we saw in this case does not seem to rise to the level of when a mistrial should be declared. So again, this is, I guess, what you can call strike three, the third argument, which really should fall flat. And we haven't even seen yet the response by the state, but this would kind of be my response as I'm going through this motion. So that's going to be it for now. Thank you all for watching. If you haven't yet, please subscribe, like, and we will see you next time.